Hello. I had to go into work today because, well, sometimes you got to go into work on a Saturday if you want to make that money, make that bread. Right to Record, who's got to be my favorite bobblehead. I mean, if I could get a Jerry Bushman bobblehead, I might trade my Right to Record bobblehead for a Jerry Bushman bobblehead, but I'm really happy with my Right to Record bobblehead, even though he doesn't post often. He tried to tell me that my interpretation of the Hiibel decision was in error. I misunderstood the court's opinion. And, that's an interesting thing for Right to Record to say, considering he never was a lawyer. So I don't know why I would just take him at his word. So I asked for a source, because that's what you do, You always got to ask for that source. He comes back with, well, the opinion itself. That would have been the opinion of Kennedy, I believe. And the dissenting opinions of Stevens and Breyer. They all aligned. The stars aligned. I mean, what were they even dissenting about? I mean, they all agree that John's stupid. So normally, I will admit to you, I don't read dissenting opinions. I know a lot of the sovsits and YouTube lawyers love to read dissenting opinions and cite them. Ooh, well, this justice, he's really smart and he disagrees with you. Yeah, it's in a dissent, but he's really smart. But he's also in the dissent. So that means he lost. That means that the rest of the justices, who are also really smart, disagreed with him. But yeah, I normally don't read dissenting opinions, but because he said that there was evidence in the dissents that my interpretation of the court's ruling is in error, I of course went and read those dissents. Now, there were two. The first one was by Justice Stevens that I read, and he was by himself. And he said two things that I think really affirm that my interpretation is correct. Number one, he said that the main court decided not to address whether or not the giving of the name was testimonial. It's almost like the justices didn't address it. Like I said, they didn't address it. They said in the main opinion, but we're not answering that question now. And Justice Stevens says they said they weren't going to answer that question. It's amazing. It's amazing. It's almost like when you read it just to read it. I mean, everybody thinks I'm biased because they're biased and they're reading things with their bias, and I'm reading things like this is the words on the page. These are the words on the page. Being a practicing attorney, you have to read these court decisions, these opinions, for the actual words that are on the page. And you have to listen to the judges when the judge is giving his order. You have to listen to the words that are coming out of the judge's mouth. And when you're reading an order, you have to read the words on the page. And so, Stevens, who I also don't particularly agree with, agreed with my opinion of what the majority opinion was. That is the law. And like it or not, that is the law. Now, there is the other dissent that was written by Breyer, and two other people joined Breyer in that other dissent. And Breyer's position was, I understand it's all essentially dicta, but Terry said that, and and this is the Terry stop, Terry v. Ohio. Terry said that the purpose of the Terry stop was so that the officer could stop the suspect and ask questions. But the suspect doesn't have to answer. That's what Terry held. And they go through a line of cases, all the way down to Illinois v. Wardlow, which is a 2000s case. I think it's like 2001 or 2002, somewhere in there. Decided relatively recently compared to Hiibel. Hiibel's like 2004. And Breyer's position was all of these cases, every last one of these cases said that the suspect can remain silent. The Terry stop allows the officer to stop the person for investigative detention and ask the person all the questions he wants to. And that person is free to shut his fucking pie hole. And Hiibel came along and changed that. Suddenly a state can, just merely by writing an order that a suspect has to give their name, if the officers have reasonable suspicion, suddenly all that right to remain silent is gone. You can no longer remain silent. They didn't like that. And it was very short. It was a very short opinion. And all they were saying is that we think it is an error for the court to move away from the last 20 some odd years of you have the right to remain silent. And I strongly agree with the Breyer court, or with the Breyer dissent, now that I've read it. But that doesn't make it into the law. And that doesn't mean that you can overturn Hiibel, because Hiibel has been used and cited over and over and over again for the last 14 years, 15 years almost. I don't know what month it came out in, but 14 or 15 years it's been cited. And not overturned. So at this point, that dissent is probably not going anywhere fast, because while they had 20 some odd years of it being the law that you can remain silent at a Terry stop, now we have 14, 15 years of you have to give your name if there's a statute on the books saying that you have to give your name if there's reasonable suspicion. Now you have to give your name. You can no longer just remain silent. So, thank you, Right to Record, for pointing out that the dissent agrees with my interpretation of the majority opinion, or at least Stevens did. I look forward to you finding anything that leads to a different opinion about whether or not you can take the fifth on providing your ID. And I'll look forward to hearing from you. Thanks for watching. Have a great day.